Welcome to the Ada K Show. I'm your host, Ada K, and I am a criminal justice major. I am also a deaf courtroom commentator, breaking down the gripping courtroom drama while providing full ASL interpretation, making justice accessible to everyone. Grab a cup of Java and let's dive in. And don't forget, comment, like, and subscribe. And if you love this channel, please become a member. We're back. Well, we didn't go anywhere. We just teleported. Welcome, y'all. Today we're going to be talking about the Maya Kowalski appellate bombshell. From $208 million to zilch. Yep. And I remember a lot of us having conversations when they got the awardment that we all agreed, we really, in our heart of hearts, we wanted them to get the money. But we really also felt that, guess what? I don't think it's going to happen. And that's what happened. So we'll see. There's more that can be done. Only more pails. But thank you, Angela. Thank you, June, for hopping in. Oh, thank you. Uh-oh. Where did that document go? There it is. I got to get the document up and get it to where I can read it, where y'all can, looks like I'm looking at the camera, which is nearly impossible. Enable editing. Okay. I will share it with you guys. I know other people have done things. Lawyers have done things. People have done things. There we go. That'll help a little bit. I'm trying to, there we go. I love it. I figured it out. But before I get to the document, let me say hello to Miss June and Angela. Thank you for all your comments. We're going to get into this because we have a third show to do tonight. So I only have about an hour and a half, a little more than an hour and a half to get this done. Okay. So let me go over here and get the run. Well, let's start talking about the case and then we'll look at the pages. Now, mind you, there are what, 40, 50, 60 pages in this thing. I am not going to read every little section. In fact, I have not looked at this. 47 pages. So we're going to skim through it as best we can. As best we can. Let me just come down a little bit. Yeah, I think that's what I'm going to need to do. There we go. Let me do this to go up and down on the pages. So the thing is that those of you who may not know about this case, let's talk a little bit about it. So here's an overview and the stakes that the party involved have. This is the appellate, John Hopkins, All Children's Hospital, J. Hatch. I am going to shade so I can read better. Appellees Maya Kowalski, Jack Kowalski, and the estate of Betta Kowalski. Original verdict was jury awarded damages, false imprisonment, multiple dates, intentional infliction of emotional distress, wrongful death of Betta Kowalski, and medical negligence, battery, fraudulent billing, appellate outcome. The Second District Court of Appeals reversed the trial court's judgment due to misrepresentation of the Florida statutory immunity law. I just say cited. I'm not going to read all the cites. An improper denial of the J. Hatch motion for direct verdict and new trial. The legal flashpoints is one, statutory immunity under Chapter 39 key statute cited Florida State 2016. The legal question is this: was J. Hatch immune from civil liability, for the actions taken while reporting can't do that. While reporting suspected child abuse and implementing court-ordered shelter care? Trial court errors. It only applied immunity to the initial abuse reports, not to J. Hatch's ongoing role in executing the disciplinary, I can't say this word, dependency court orders. Thank you. I had to think about it. Appellate court's view is that J. Hatch acted in good faith under the court order and should have been immune from most claims. Well, let's talk about that. Yes and no. But the person that worked for J. Hatch, that investigated, started the claim of child abuse, and was the key figure in all of this, has done this before. It's not a one-time deal. It's not an isolated case. Sorry, I got a bad itch. I've been sitting down all day, and now my back is itching like crazy. And so, unfortunately, this woman, I don't think she works for them anymore. I think she's retired. But this woman, y'all, I wouldn't want to see her. She came in looking like an actual physician, which she was not. Yeah. So we'll get into all that. But I'm concerned about the level of the immunity because of the level of the claim. We'll get into it. The direct verdict and new tri-standard reviewed the de novo, which is legal sufficiency of evidence. The appellate findings was that the trial court should have granted J. Hatch's motion due to insufficient evidence and several claims of persuasive legal error. The emotional and the factual timeline, 2015 to 2016. Maya's CRPS diagnosis and ketamine treatment diagnosis with complex regional pain syndrome. In short, she had CRPS, ketamine treatment diagnosis with a complex CRPS. This is all treated with a drug called ketamine, including a treatment with ketamine that induced coma. It was a selective medically induced coma, which was done in Mexico, and Donna Hanna oversaw the ketamine infusions via a chest port. She went to Mexico, was admitted into a hospital, had a port admitted into like a chemo port where it goes directly into the heart, and they put her in a medical induced coma. This was in hopes to shock the system, basically. I'm putting it in very layman's terms, into changing or stopping what was going on with her body. It was a crash halt is what they were looking for, and apparently had some success. October 7th through the 13th of 2016, Hopkins um, admissions and abuse allegations. Maya was admitted to JHatch in severe pain. Miss Kowalski demanded ketamine. The hospital refused the ER level dose. Social workers called Florida's Child Abuse Hotline twice. So what happened was that Miss Kowalski, who is now deceased, uh, at her own hand, went in and demanded the ketamine at a high doses under the direction of the Dr. Hannah, who had been treating her daughter. Unfortunately, the hospital disagreed with this method, and since they were in their hospital on their property, there was nothing she could do. So when the social workers were called through the abuse hotline, Dr. Sally Smith consulted. The dependency petition was filed October 14th of 2016. Maya was sheltered by the state with an order of no contact with Ms. Kowalski. Now, JHAC became the shelter in place under the court's jurisdiction. The hospital staff followed strict court orders on the visitation, communication, and medical decisions and directives. So basically what happened was that they, i.e. the hospital, became the guardian ad litem, and she was to remain in the hospital until this had been resolved. The parents were both put under supervision. Both parents were watched and viewed and investigated, but the mother was the key person in this investigation. Munchausen by proxy is what they were accusing her of because they didn't understand this very rare medical condition. She was held in a hospital room that had an EKG machine and had cameras. This was highly unusual. The reason why they held her in the room, because they wanted to watch her. They put a bedside commode just far enough out of reach of the bed that Maya would have to get up on her own 2 feet and walk to get her to go to the ladies' room. There was a lot of other bad stuff that went on. She was forced to take off all her clothes except for panties and a sports bra. She was forced to be photographed before she could visit with her mother on the phone. The phone calls were very much monitored. They spoke in Polish because they're Polish. They're Catholic, Polish Catholics. And the mother and her always spoke in Polish, not English. Well, she couldn't speak to her mother in Polish anymore because they didn't understand it, the ones who were supervising the visitation via the phone or in Zoom. I'm out of water. I have coffee. Yes, I have coffee. Cold, but I have coffee. So things continue to deteriorate October 18th through January 6th of 2017. The isolation and surveillance moved into the EKG room, as I discussed. And she began her video surveillance. Allegations of psychological manipulation by social worker Catherine Beatty. Beatty? Not Betty, it was Beatty, I think. Maya denied communing. Maya was denied the right to take her communion from her parish priest. The visitation from that priest, they restricted her from speaking in Polish. Now, the thing about this is that they did have a Catholic, they could do Catholic services. They had a chapel, they had a priest or chaplain. And Maya was an extremely devoted and devout Catholic. And she wanted to have her communion. She wanted to do all of her worship rites, and they very much limited. They were afraid that the mother would get access to the Eucharist and taint it with ketamine, and the priest would bring it in. So they refused her any and all outside involvement with anybody. If she wanted to, they would try to make arrangements through the hospital. They restricted her from speaking in photograph. Like I said, they photographed her before a court hearing. Maya felt very humiliated, and she was. January 7th of 17, Betta Kowalski, if I'm saying it right, ended her own life one day after the court executed Maya's shelter stay in place. She left an unaliving note blaming J. Hatch, the Department of Child Protective Services, and Dr. Smith. January 13th of 2017, Maya's release dependency case was dismissed. Maya was weaned off of ketamine and later recovered physically. Maya was not even able, she wasn't able to do anything until her mother had deceased. Once her mother was deceased, the father had already been cleared of any involvement or problems, and he regained custody. The legal analysis and implications of immunity scope of misunderstood trial court narrowly applied immunity only to the initial abuse report. The appellate court clarified that immunity extends to all good faith actions under Chapter 39, including shelter care and implication of an impact on claims. Most of the claims were false imprisonment, emotional distress, or wrongful death. They all stem from the actions taken under the court orders. These should have been barred by the statutory immunity. The problem is that I want to go back and talk about the immunity. A lot of times only applies to one event. The appellate court and judges have made it across the entire event. Maya had multiple individual claims. If you look at the different situations, there was a woman who told Maya that she would become her mother and encouraged Maya to sit in her lap and all but demanded it. And she was a supervising agent for Maya when she would speak with her mother on the on the telephone or in the Zoom calls. She would be just off of camera. There was some very big questioning in this trial of the stability of this woman's mental health, because this woman was no relations, no friends. She was a court-appointed supervising agent. Okay? So, precedent cited that reasonable cause to report equals immunity. Motive irrelevant if reasonable cause exists. Daugherty cases. Daugherty cites, good faith participation in the child protection equals immunity. Basically meaning, if I honestly believe that what I see or what I perceive is an abusive situation, then I report that to a CPS or an agency, then I'm protected. Even if I'm wrong as wrong can be, I am protected. The problem is, how do you prove in a court of law between a lie and what someone believes or perceives? I had lost my husband to prison. I had his family and other people call CPS so many times on me for no reason whatsoever. People were calling CPS on me when my children were visiting their grandparents and not even in town. I had a claim on me when my daughter was 8 hours away, and someone said at 3 something in the afternoon that they witnessed me beating my daughter outside my car because she did not want to get out of the car. Stupid, because my daughter wasn't even in town. This got to the point that I was trying to get charges brought on these people But the problem is, and the problem still remains, how do you prove that someone's belief isn't as they say? It doesn't matter whether I'm innocent or guilty. On my end of the boat, it's all about what do they believe? Do they believe that what they are seeing is abuse? If that's the case, they report it, they're protected. People use that system all the time to get back at people. It really happens a lot in divorced families. And when the reporter is investigated, all they have to say is, I truly believe this is what I understood, and this is why I reported, and they hide behind that shield. Kind of the same thing here, just different scenario, but similar. Okay, the undercurrents of Mia's testimony, the isolation, the disbelief, the emotional trauma of Mr. Kowalski's testimony, and the powerlessness, the confusion, the fear of Beata's self-unaliving, a tragic climax that underscored the emotional toll of the dependency proceedings. This reversal doesn't erase the pain that Maya and her family have endured, but it does reshape the legal narrative. Was this a case of medical overreach or hospital caught in the crosshairs of a flawed child protective system? In my humble opinion, it was a little bit of both, because a lot of this stemmed off of the word and testimony of one woman. Nurses fell in line because they were afraid to lose their job. The appellate court says that J. Hatch followed the law. The jury said otherwise. And somewhere in between lies the truth, the trauma, and the tragedy of Beata Kowalski. So what we're going to do is I'm going to pull up the document. Give me a second. I got to figure out which is best for me. Probably this. Okay. Let's see if I can. I'm going to embiggen this as big as I can. As big as I was going to get as big as I can, because I's kind, I's smart, I's important. Okay, there it is. The District Court of Appeals of Florida, 2nd District, John Hopkins, All Children's Hospital, and Maya Kowalski, Jack Kowalski. Oh, I'm putting the cursor in the wrong place. Appellate judge from the Circuit Court of Sarasota County, Hunter W. Carroll, judge. And listing Andrews, Baldwin's a Life Group, Tampa, Medic Hospital, blah, 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 blah. Black judge. Judge Hopkins of All Children's Hospital, JHACS, appeals for the first judgment rendering against it and in favor of Maya Kowalski, Jack Kowalski, and the estate of Beata Kowalski, collectively the Kowalskis. The final judgment awarded damages to the Kowalskis for the false imprisonment between October 7th and October 13th, intentional infliction of emotional distress, wrongful death, and intentional infliction of emotional distress, false imprisonment between the 18th of October and the 20th of October 2016, false imprisonment on January 6th, 2017, medical neglect, battery on January 6th of 17, battery for unspecific dates, and fraudulent billing. The trial court's erroneous interruption and application of this interpretation, cited, and the immunity afforded thereunder, as well as the trial court's erroneous denial of J. Hatch's motion. Directed verdicts of J. Hatch's motion for a new trial required reversal of the final judgment. I'm not going to go through every page. We got 47 pages. Dr. Hanna, by the way, did not testify. We are not going to rehash everything I just told you. I have to be honest, y'all, I'm really struggling. I am so tired. Only had about an hour's sleep last night. Oh, by the way, Miss Kowalski, well, let's start right here. Miss Kowalski would not have signed the transfer because they believed it would mean admitting guilt and blame. They refused to take the Kowalskis any responsibility because they didn't have any responsibility. It was a legit medical condition that this girl continues to suffer from. It's under control for the moment. Kowalski testified. I want to get away from all the background. I kind of just gave you a background of this. Here we go. The analysis and standards of review. This is what I wanted to get to. Hold on, guys. Beata. Thank you, June. Beata. I'm horrible at these things. Horrible. I had a neighbor once who heard through the walls a yelling and banging. I told my landlord, sweetest little couple ever, and they called the CPS who came and asked me what I heard. She left. Wow. Yeah, I know. Beata. Okay, thank you. The standards of review. The issue of the statutory interpretation are reviewed de novo. A trial court decision on the motion for direct verdict presents a question of law, the sufficiency of the party's evidence that we reviewed de novo. Oh, I keep rolling on the wrong page. When considering whether a trial court should have granted directed verdict, we must evaluate the testimony in light of most favorable to the non-moving party, and every reasonable interference must be indulged in favor of the non-moving party. That would be the plaintiffs. Our review of the denial of the motion for the new trial is for an abuse of discretion. In reviewing an order on the motion for a new trial, an appellate court should consider the totality of all errors and improprieties. Pretrial, J. Hatch moved for pretrial summary judgment based on the immunity efforts pursued to the section of 39.203 cited. J. Hatch argued as relevant to the appeal that every claim against it, except for battery claims, was precluded as a matter of law because J. Hatch had a reasonable cause to report suspected child abuse and was otherwise participating in a Chapter 39 proceedings. They reported that her parents were abusing her. The trial court granted in part and denied in part the motion based on interpretation and the application of Section 39 cited to the Kowalski's claim. J. has argued in its post-verdict motion that new trial is warranted based on the trial court's narrow interpretation and erroneous application of the statutory immunity. On appeal, J. Hatch again seeking a new trial based on the court's erroneous rulings with regard to the Section 39 cited that their prospective impact on the trial. So basically all this is saying is that they believe because their staff acted in good faith and under the law is protected, and they did what is required by them under law, they are protected. They have no responsibility or recourse. They did what they thought was right, and no other responsibility should behold them. The trial court considered two sections in the Chapter 39 applicable proceedings addressing the statutory language. cited address mandatory reporting of a child abuse and provides in a relevant part any person who knows, quote, any person who knows or has reasonable cause to suspect that a child is abused, abandoned, neglected by a parent or guardian. I'm going to put or guardian. That I think is in there. Shall report such knowledge or suspicion to the department in the manner of prescribed by subsection. Physician, nurses, and hospital personnel engage in the admission, examination, care, and treatment of a person, as well as other health and mental health professionals, are required to provide the names of their abusers to the hotline when making a report. Suspected child abuse by a parent must be reported immediately, no delay, and any person who is required to report knowing or suspecting of child abuse and who fails to do so commits a felony. And that is where J Hatch won. Any person, official of an institution participating in good faith in any act authorizing or requiring by the chapter or reporting in good faith any incident of a child abuse, abandonment, or neglect to the department or any law enforcement agency shall be immune from civil or criminal liability which might otherwise result in reasons of such action. In other words, the law's on the side of the one doing the reported, not on the side of the one that's being reported on. Now, I've got to get some ice. I know my eyes are squinting a lot. They've been hurting all day, y'all. These allergies have been killing me. I'm doing good reading. There are two ways in which a doctor can be immune from civil liability for making an incorrect report of child abuse. Immunity exists as a matter of law if a doctor has reasonable cause to suspect. Hold on. Thank you. Immunity exists in the matter of the law if the doctor has reasonable cause to suspect that a child has been abused or makes a report of abuse as required by law. In that event, there is no need to determine whether the doctor acted in good faith. Once reasonable cause has been shown, the reporter simply complying with the statutory mandate to make a report. Wow, what do y'all feel about this? This really, I fall under this somewhat because as a chaplain, volunteer firefighter, we all are responsible for making reports if we see something, but they do hold people in the first response, medical, legal career and field at a higher level of requirement. Unfortunately, today, do y'all remember towards the end of the day today, I got a phone call. I typed I had an important phone call. Kind of scared me because it was a call from Adult Protective Services. Now, I have several disabled clients and several deaf clients, and I have a lot of people that I've been working with in ministry from the flood on the 4th of July. And I got a call that somebody I got a call that there's been a report on one of my clients, and now I'm involved as a professional. It's horrible. And I know to err on the side of caution is better than not. But in this situation, I think there was a breakdown. It became an agenda of one person, if my memory serves me correct. And that one person spearheaded all of this. So let's see if we get into this. Okay. If it appears that immediate safety or well-being of a child is endangered, that the family may flee or the child will be unavailable for the purpose of conducting a child protective investigation, or that the facts otherwise so warrant that the department shall commence an investigation immediately regardless of the time of day or night, and all other child abuse, abandonment, or neglect cases, Child Protective Services shall be committed within 24 hours of receipt of the report. So they have to make their first contact within 24 hours. The shelter petition in this case alleged, and the dependency court found, that the shelter was appropriately based on the evidence of the abuse and immediate danger. So what was the abuse and immediate danger? They were saying that the mother was I can't say it now. Munchausen syndrome by proxy. I need water really bad, y'all, and I don't have any. I may have to run and get some. That the mother was medicating and encouraging her daughter's medical condition for attention. The shelter petition in this case and the dependency court found that the shelter was appropriate based on the abuse and immediate danger that was reported. Oh, wrong one. Is by definition of operating in good faith. However, the absence of reasonable cause does not prove liability. It merely removes the immunity and would otherwise apply as a matter of law. If the objective evidence does not support a conclusion that the doctor had reasonable cause to make the report, the doctor may nevertheless claim immunity from civil liability by showing the report was made in good faith. So he can sit there and say, well, I thought. It's like these kids that come into an emergency room and they're covered in old bruises. And then they come to find out that the child has a problem that causes bruising, or they have brittle bone and they have a ton of broken bone. They take an x-ray. You see a lot of fractures. They automatically think abuse. And they report it. And then they find out a day or so later that the child has brittle bone disease. Oh, my bad. Sorry. Yeah, that's how that goes. My husband was a physician. And yes, I learned a lot about this. I mean, we talked about this in length. Now, he was not a pediatrician, a physician of children. He was internalist and dealt more with the elderly people. So his was more elderly abuse. All of this is cited. Blah, 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 concluded that if the reasonable basis exists to report child abuse, then the motive in making the report is irrelevant. Based on the facts before it, the above cited proceeding, the trial court determined very easily that J. Hack had reasonable cause to report suspected abuse to the department hotline. Accordingly, the trial court found that J. Hatch was entitled to Section 39 immunity from any civil claim which might otherwise result in the reason of the reports. But the court said nothing of the immunity for the claims resulting from participation in good faith in any act authorized required by Chapter 39. I like let's look at number 9. The trial court exercised trepidation in applying the untoward analysis insofar as, that's not untoward, what is that? court or whatever concludes that the immunity the immunity that is afforded to the medical doctor is not the same as afforded to the ordinary citizen, where neither in section 39 201 or 39 203 the differentiate between the doctor and ordinary citizen, except that the former are required to give their names when making the report, while the latter may remain anonymous. While we might agree with the trial court on the narrow issue, application of the statutory immunity is between doctor and ordinary citizens is not before us. So, that is so true, and that's one thing people don't understand. When you are in the medical field, you are required to give your name, the physician who is treating the patient, making the report. It is a requirement, and my requirement is I've got to get me some water, boo. I've got a thing right here. I'll be right back. Oh, Soxy. Look at baby girl. You had no food, no water. Okay, I'll get you in a minute. Oh, I love my liquid IV. So that is, I remember my, I had a conversation with somebody about this, and they said, no, it doesn't matter who you are, where you work, you're protected under immunity. You don't have to give your name. I'm like, yeah, you do. If you're a physician or representing a physician, you are required by law to give your name. That's the way the law is written. How many of you guys have ever had liquid IV? I love liquid IV. It got me off of all my Dr. Peppers, that's for sure. Okay. So let me scroll back down. This is kind of weird because these pages, that's 15. What is that? 16. If you look here in 15, it says citizens here. No, okay. I'm sorry. Go up here. The fact of this case are unusual. Well, the facts in this case are very unusual in that the reporter, for the purpose of this section 39-201 and 39-203, remained a participant in Maya's care. Now, that's something that is an issue in and of itself. And I brought this up when we watched the trial. Why is a reporting person able to maintain the care of Maya? They should not have. That person should have been removed from the case, and another physician or team should have taken the case over. Okay. The fact that the participant in Maya's care beyond the initial shelter hearing was required to comply with the dependency court order by virtue of the department's design. Maya's. Let me scroll down. Oh, that feels better. Placement with J Hatch. So they were required, the hospital, to follow all of the guidelines set by Child Protective Services. But in my humble opinion, it went a little further. It got to the point that it wasn't Child Protective Services that was creating and designing and initiating the plan of safekeeping, or the safety plan, as they call it, for Maya. That one of the people in the hospital started intervening into that safety plan, and it got really out of control. Part of that is what led to the death of her mother. The orders required JHATS to comply with the visitation guidelines set forth in the orders, as well as manage correspondence between Maya and Miss Kowalski. Moreover, the orders directed that the court would not micromanage or countermand sorry, JHAT's policies, that the absence clear and compelling reasons JHAT staff was to be free to address the medical needs of their patients without the court, the parent, or others interfering with the professional judgment. So basically, there was no safety net. If the hospital was acting in bad and wrong faith and was actually abusing Maya, there was no one to govern over them. The hospital had nobody to answer to. They had free and clear jurisdiction over her treatment, her medical needs, without the court intervention, the parents, or anybody else interfering. In other words, they pretty much became the guardian, could do whatever they wanted. That I struggled with in this trial. I think if I was on the jury, that would have been a hard one for me to get past. Jay Hatch was required to take part in a sheltering of Maya by virtue of shelter order on October 14th of 2016. The department sought to have Maya sheltered based on ongoing abuse accusations. I don't like this. They said ongoing abuse. It was abuse by the hospital, not the mom, in my humble opinion, but the accusations of abuse and immediate danger. See, the mom is not here to defend herself. It is alleged. The dependency court sheltered Mia. The department authorized the determined her placement, and the department placed Maya at JHATS for ongoing medical treatment, including psychological evaluation and weaning off of ketamine. Within the text chapter of 39, the legislation established its intent explicitly. The purpose of this chapters are to provide the care, safety, and protection of the child and prevent the occurrence of child abuse, neglect, or abandonment. So their job was to intervene and to act as guardian and protectors where the parents were failing her. The hospital was supposed to pick up the mantle and protect this child. The legislature further states that it is intent on Chapter 39 to liberally interpreted and construe its conformity with its declared purpose. Yep. The courts were not allowed to extend, modify, or limit the statute's express terms or reasonable obligation implications because to do so would have obligated legislative power. So, in other words, they couldn't step in at that time. There's a bunch of cited. Let me skip because we're going to be here all night. I got an hour to get this done. Do y'all have any questions? I'll be happy to answer them. Here, the trial court erred by considering the entirety of the section and its application of the facts in this case beyond JHAS immunity claims premised on the immediate result from the report of suspected child abuse. Nothing in the record suggested that JHAS participated in implementing the dependency court orders. It was as it was required to do so was not done in good faith. See, this is where I struggle. Good faith. Who determines good faith? Who determines that? It's so hard. Now, the process was slow. It was painful for the daughters. Nothing revealed the investigation was not insinuated and conducted good faith. So, in other words, they found that nothing contradicted the good faith. So it's like, okay, I'm telling you I'm acting in good faith. I have an ulterior motive. I want custody of this child because they have a big bank account. Mommy and daddy have money. If I get custody of this child, I get access to that money. So I'm going to create a situation where I can report them and then I become the guardian ad litem or safety, the safety plan for this child. And I gain access to the money while I have custodian of the child. And I have this whole plan I've concocted. But I get what I want. The child gets taken away. I become the temporary custodian of that child, which means I get access to whatever the child has, the money. And then all of a sudden things start going wrong. All I have to do is say, I acted in good faith. I truly, in my heart of hearts, believed this was going on. And boom, you're fine. You're safe. Very easy to manipulate that. Very easy. But it's to me, it's different when it's an outside individual who sees a very upset mother at Walmart having a bad day. She's raising her voice. She's struggling with the child, and the child tries to get away. She grabs the child by the arm. She pops the child on the butt. She's screaming at the child, and you believe that child's in danger wholeheartedly, and you call the police. Okay, but a hospital, when this child has had a history, instead of really diving into it, they see the child had a history. They didn't agree with the medical treatment with ketamine, which was administered by a physician. And that's where I have problems with physicians. You got one physician who doesn't like the way this physician's treating, and it's experimental or it's not what they think it needs to be. So they are going to call in abuse. Munchausen's by proxy. Oh, I saw a chat. But the legislature did not condition immunity on doing more than seeking medical assistance in good faith. The legislature could have imposed more conditions. The statutory schemes at the issue is intended to protect those who might be overzealous in protecting children for potential abuse. It's one thing to be overzealous. It's another one to be, I mean, they went above being overzealous. They did. Now, Section 39, 201, 203 does not provide absolute immunity, provides immunity from liability that might otherwise result from good faith reporting or good faith participation in the acts authorized or required by the chapter. Protects against liability for carrying out protective measures on behalf of the protected class. It does not protect against failing to carry out protective measures. So, if you are given orders by a court that child was to stay in the hospital and be sheltered and you didn't follow those orders, then you are not protected. The trial court found as a matter of law that J. Hatch had reasonable basis for suspecting that their patient was subject to child abuse. J. Hatch acted in good faith in reporting that suspicion, and J. Hatch could not be held liable for any cause of action directly arising from the sheltering of the child pursuant to the court order. Unfortunately, these findings are rendered meaningless at the trial itself when the court permitted the Kowalskis to attack J. Hatch based on suspecting abuse. It motive for reporting and suspicion. And present to the evidence of the jury's psychological impact of the court-ordered sheltering period. So, to sum that up, the hospital won, and they're not going to see a penny. The trial court found in section 38.9, blah, blah, well, cited, immunity flows to civil and liability may result for the reason of the child abuse report. Without question, the investigation, sheltered and removal, custody, and providing visitation all are outcomes of the logistically that could occur from a report to a child abuse to an abuse hotline. So, yeah, think about it before you make that phone call. Yet the trial record, I'm drinking watermelon flavored. Whew, it's got a sour punch. The trial court failed to give effect to its interpretation by permitting the jury to hear significant inflammatory testimony concerns and the restrictions put in place by a disciplinary dependency court, and the impacts of those restrictions on the Kowalskis. For example, Mr. Kowalski testified that Miss Kowalski lost consciousness and fell on the floor upon learning that she was not going to be able to see Maya. And during that time, she was unable to see Maya. Miss Kowalski deteriorated and was losing hope. He repeatedly testified to the profound impact of the dependency court order that Mr. Kowalski found profound impact. Oh, Mr. Kowalski, sorry. Maya also testified to the impact of the dependency, I want to call it discipline, dependency court ordered on her, from anger to not being able to speak with or see her mother, to feelings of isolation. Maya testified that she was suspicious about the comments made to her and the restrictions that were placed on her. No one ever directly told her what was going on, and she had to figure out for herself that she was being stripped from her family. Quote again, my care journal, unquote, and that she listed names of the JHATS doctors and nurses with notations and drawings. I was trying to get out of the hospital. I'm only 10, and I'm thinking if they think like you, then I'll get out. So in other words, if she conforms, she'll get out. They're saying here that the trial court erred by not giving effect to that portion of the statute to which assigned meaning. Provides immunity from civil liability, which might otherwise result of both reporting in good faith and instance of child abuse. The problem is that so many people are fearful, very fearful to come forward, and this protects them. 91 of Maya's 97 days in JHATS were the result of dependency court order. Within 7 days, JHATS was where the result of dependency orders wherein the department had been given placement and the care responsibility of Maya, where she stayed protective supervision. JHATS argues that the trial court erred in interpreting and applying this section. And that's where this sits. You know, I really feel bad for the judge, because I think they had if my memory serves me correct, I think they had a decent judge. Any of y'all remember the judge? Welcome, everyone. Thank you for joining us. Go over this with Ada. Please remember to like and share. Why do you have no sound? I haven't touched anything. Who does not have sound? Do you have sound, June? The closing arguments were also inflammatory. Counsel for the Kowalskis argued that JHATS took Miss Kowalski out of the game by changing its diagnosis and treating the Kowalskis like criminals. Well, they kind of did. Counsel then went through JHATS defense, because if we get rid of the defenses, because if we get rid of the defense, then all that is left is Kowalski's case. Counsel for the Kowalskis argued that something happened between Mrs. Kowalski and JHATS that ticked JHATS off. I remember that. They said that the mother jumped them because they didn't do what they were supposed to do. She was micromanaging them, and they got pissed, causing JHATS to call the department, and that JHATS was not going to let this brusque lady with an Eastern European accent come in and tell them how to do their job. I remember that. I was like, Eh, I've been in a position where I've told doctors and nurses they're not doing something right. They're human. That's why they call practicing. They argued that J. Hatch called the department hotline and was retaliatory against Miss Kowalski and that she committed self harm that ended her life because she knew that if she did not take drastic actions, Maya would end up in the same kind of foster care, in some foster care or die. Yep. We've covered this gets pretty multiple. It hurts to keep my eyes open, y'all. We need to consider whether the hospital was without legal authority or calling authorized a question of law. And they did. They sided with the hospital. What time is it? I'm skimming. According to J. Hatch, the motions for directed verdict in this on the claim of false imprisonment for the period of October 7th through 13th of 2016. According to J. Hatch's motion, directed victim to claim false imprisonment for the period of October 7th to October 13th. Let's skim. So they're saying that the Kowalski's evidence was insufficient as a matter of law, and this court agreed with that. To support the claim, the plaintiff must prove wrongdoers conducted an intentional or reckless that it is he intended his behavior when he knew or should have known the emotional distress was a likely result. One of the things that bothered me is the games that they played. I'm going to stop reading for a minute and I want to talk about the games. How many of y'all, by the show of a hand, actually watched this trial? I'm going to skim while I'm talking to y'all. How many of you actually watched this trial? This was really a good trial. I wish I knew now what I knew. I wish I knew then what I know now. I would have definitely viewed it in a different light. The Kowalskis presented no evidence that Mrs. Kowalski was the target of any of the conduct alleged to be outrageous. Rather, the heart of the Kowalskis' claim, repeated various ways and brought multiple bench conferences and asserted before the jury, was that the separation of mother from child with knowledge by both and without the ability to combat it. The Kowalskis argued a plan that is told to the mother that we're going to take your child. There is nothing you can do about it. Quote. Oh, okay. June saw it. Oh my gosh. It was a heartbreaker. This little girl got on the stand and she was freaking amazing. There's nothing you can do about it. The real outrageousness of the systemic nature of this action against Mrs. Kowalski through this and everything, every contact that she had, everything she learned reinforced that there was a plan to take her daughter away. And that is outrageous in our society. Raises the pressure on Mrs. Kowalski. If this doesn't get her, let's suggest that Mrs. Kowalski get a divorce. And if it doesn't get her, let's tell Maya that I'm going to be her mother. See, this is something that really got me going, and I got angry. I got super angry because you have a woman in authority at a hospital telling a young child that she can adopt her and become her mother. What? I was like, no, hell no. Yeah, that did happen. The thing is that they kept raising the pressure. They were pressuring the husband, the father of this child, that he could not see his daughter. He couldn't see his daughter if his wife was with him. He had to come alone. He couldn't talk about anything. Couldn't bring up how your mom's doing good. Mom sends her love. Could not do any of that. He had to very limited communication and was supervised. They were also told, if you get a divorce, sir, you can get your daughter. And that was being entertained. And so this was, and once again, when I saw this case, I knew nothing about it. I literally walked into this case just knowing the name of the people because it was the state of so-and-so against so-and-so. That is all I knew. I literally was like a juror who never heard of any of this in my life. And I watched this, and it was one of my first cases early on in my thing. And I didn't do research. And I have to tell you, it was so horrible that by the time it was all said and done, that woman, and the woman's from another country. She was not born and raised in our culture. So her culture and her way of doing things and taking care of her child had some differences that the Americans did not appreciate. So they keep adding this pressure. The Kowalskis, I want to call them the K's, acknowledged that the statements were not made directly to Miss Kowalik because she wasn't allowed to be in the hospital, but were funneled through to her by proxy, which was her child and her husband. See, they were interviewing and talking to the child and husband, but not the mother. So they went to the husband and said, if you get a divorce, you could get your daughter back. The woman who was supposed to be supervising her said, hey, I'll be your mama. You'll be fine. I can be your mama. I'll adopt you attitude. I mean, that's a crazy nut job. And she was in authority. She was a supervising agent. She was the one that supervised the phone calls with her mom and was a total witch about things. She was not an impartial party. So the Kowalskis acknowledged that these statements were not made directly. I'm sorry, did that Mr. Kowalski or Maya relayed that they had seen or experienced is not evidence that J. Hatch actions were directed to Miss Kowalski. So they're saying here that hearsay pretty much is what they're saying here. I think this is absolutely insane. And there was no evidence that Mrs. Kowalski was somehow the target of statements made to either Maya or Mr. Kowalski. Yeah, it was. Moreover, the trial court recognized the allegations in the operative complaint were insufficient when it granted J. Hatch pretrial motions to dismiss an IIED claim. With the exception of the actions immune under Section 39203(1)A, the assertion that Ms. Kowalski suffered from Munchausen syndrome by proxy, there's little difference between the allegations the trial court found legally insufficient. As to Mr. Kowalski's claim that the evidence presented as to the estate claims, the Kowalski's evidence was legally insufficient to survive direct verdict. The intentional infliction of emotional distress on Maya Kowalski and denying J. Hack's motion for directed verdicts specific to Maya's IIED claim, the trial court considered evidence for which J. Hatch should have been immune from liability and evidence of other plea torts. This was an error. In other words, the judge on the bench, this all boils down to the appellate court saying the judge on the bench over here should have known and should have declared a mistrial or end of trial, should never allow this to continue, and should have sided with J. Hatch. End of discussion. Bye. That doesn't work. In the proceedings, as well as initial reports of suspected child abuse in the department, pervaded. I got to get over here. Miss Kowalski. Oh, I keep doing the wrong one. Kowalski's evidence of intentional infliction of emotional distress against Maya. The trial court was required to consider which JHAC's actions should have been immune from the liability and which actions could support independently pled for tort of the IIED. Okay, I'm going to scroll down because we're going to have to tidy this up. Additionally, the IIED conduct must not be violative of any other recognized tort. Plaintiff cannot transform defamation against the claim of intentional infliction of emotional distress simply by characterizing the alleged defamatory statement as outrageous. Citation omitted. So, in other words, you can't sit there and say, oh, this is outrageous, and then sue. The Kowalskis relied upon evidence of other pleaded torts in their established IIED claim. The law is clear, however, that the evidence supported that Maya 3 false imprisonment claims, as well as her battery claims and the medical negligence claim, cannot also be used to meet the legal threshold. So, just out of curiosity, yeah, Angela, what the heck? Jack contends that trial court erred in denying this motion for directive verdict and the narrow issue of apparent agency. They just keep rehashing all of this in all honesty. Thus, okay, here I want to go back up here. I think we're going to get into Miss Smith eventually. Here we go. Dr. Smith was a huge deal. Kowalski testified that he was unaware that Dr. Smith was not J. Hatch's doctor at the time he first met her, but he could not specify the date. He testified that she was wearing a white lab coat when she came into Maya's room and started asking questions. Maya testified that she was unaware who Dr. Smith was and what the capacity of the questioning Maya's father. An email dated in October 12th of 16 from the Kowalski's email address entered into evidence. In the EL, Mrs. Kowalski reported that on October 11th of 16, she and Dr. Stanley Smith, who was sent by the Department of Investigative Possible Child Abuse and Neglect, had a second visit at which Mrs. Kowalski described Maya's illness and the doctors involved in her care. All right, I think she was a nurse and she kept immaculate details. Every medicine, how much, the dosing, the time. She kept record of the physical changes and conditions, video and writing. She documented her butt off. Unfortunately, sometimes documentation can hurt you, and it did here. Rather than the Kowalskis acknowledging that they were unaware that Jake Hatch had given Dr. Smith full access of the medical records at the time such access was provided. So in other words, Jay Hatch broke HIPAA to a point, not a huge one, but to a point, and allowed her to have access to the medical records and did not consult with the parents. So Kowalski's admitted that they were unaware of her doing this. The apparent agency theory should have been rejected as a matter of law by the trial courts and directed the verdict so that the specific claim should have been granted. So unfortunately, by what we're seeing here, they're not gonna get a penny. They're just going through all the little finite details, and they have to do this. I wanna get down to I got another live to do, girl. I need to get some fresh air before I go live. Uh, mm. We might want to acknowledge that the unique position of the parties in relationship were as assert and has the power to affect the interests of the other may also apply that the heightened degree of outrageous is required to claim of IIED. Yeah, well, whatever. So what do y'all think? Do you think that Maya's family should deserve that money, or do you think that the hospital is in the right? Excuse me. I'm trying to get down to the decision. Okay. We pretty much. The case findings conducted outrageous. They're no different than the actions taken by Maya's case. The fact that Maya's case has given her vulnerable age paired with the special relationship as the patient under the care of Miss Betty, the nurse, is more compelling, which would cause an advantaged member of the community to exclaim outrageous. I don't know. So that is where we are on the documents. Unfortunately, unfortunately, um, Maya, let me see something. I need to. Let's see. Mike Kowalski is currently living in Florida. I'm doing my research while I'm live. He is currently 19 years old. If you've not watched the story, a documentary, please do. Her story had gained national attention through a Netflix documentary, Taking Care of Maya. Centers around the diagnosis of a complex regional pain syndrome, CRPS, and the traumatic events that followed in 2016. At the age of 10, Maya was in the hospital at Johns Hopkins All Children's Hospital, J Hatch, and her mother was accused of Munchausen syndrome by proxy, leading to Maya being placed in the state custody. Tragically, her mother died by self-wounding her during the whole ordeal. Maya now continues to live with her father, Jack, and remains at the center of an ongoing developing case, which we are finding today. A recent appellate court decision reversed a $261 million verdict originally awarded the family, opening the door for new trial on the limited claims against the hospital. Now, they're saying that $203 million has is going to be is no longer awarded. The other causes may have other awardment. I don't know for sure. That's something I've got to check out. Oh, Angela, I do agree with the hospital just with. Oh, I do not agree with the hospital just with reading this, considering that the nurses and all they did, but I don't see the trial. I didn't see the trial, so I have to go back and watch it for sure. I think when we have a couple weeks where we really don't have anything at all, maybe we ought to rewatch that trial. That trial had a lot of precedents that happened in that trial. Very unique trial, I will say. Um, I will tell you that there was a lot of people. I think it was overwhelming how many people felt that the verdict was just and correct. Um, that poor girl has gone through hell, and she will always have health struggles, but the emotional stuff worries me a whole lot more. It really, really does. Okay, guys, I'm going to take a short break. I'll be back live at 7 p.m. We are going to watch the teacher trial where the teacher was shot by a student. Luckily, she survived. The teacher is suing the assistant principal for $40 million. So this is going to be a little bit of an interesting case. So let's take a little breathing break. I have been at this for almost 12 hours. So I'm going to get up. I'm going to get fresh air. I'll be back here at 7, raring and ready to go, maybe even with some popcorn because I broke my fast. And we will see you in a little bit, but keep the Kowalski family. I had a teacher named Kowalski family in your prayers. This is very difficult and devastating for them because not only could she have used that money to better herself in life, but they owe a ton to their attorneys. So they need, it would have really helped. I want to thank my fabulous mods for being here. We will see you guys at 7 o'clock. Until then. Thanks for watching. Please comment, like, share, and most importantly, subscribe. I hope you have an awesome day. Till next time, take care.